14th Amendment of the United States Constitution prohibits the government from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law. Yet, it was recently revealed that the state of Florida has decriminalized the act of omitting litigants' information during legal proceedings. So wanton are the acts of judges, magistrates, and attorneys in Florida, that one attorney told her client after omitting his information that the verdict would not be up for discussion. These acts are commonly experienced by those who are engaged in Title IV cases, where the government has already put in place measures to assure compliance with whatever verdicts are adjudicated by judges and magistrates. Furthermore, the government has cast an image of non-custodial parents where society has become willing to support the defrauding practices that are applicable through the Title IV program. It is a fallacy to identify every non-custodial parent as being uninterested in their child's life. But, to garner support from society, the government had to institute this belief. The following stories document the Florida government's encouragement of those officers of the court to omit litigants' information to satisfy the state's revenue. On March 2018, Florida attorney Renita Henry was retained for a Title IV case in the 11th Judicial Circuit Court of Miami-Dade County, Florida. It wasn't long before the bad practices began, as on December 17, 2018, Attorney Henry would admit to omitting her client's information through an email to opposing counsel Emily Phillips. The information which was omitted included Delaware state tax, Wilmington city tax, and mandatory retirement salary deductions. Subsequently, it meant that these salary deductions were transposed into net income during the child support calculations. Yet, Attorney Henry decided that any refusal to comply with her fraudulent act would result in a withdrawal which occurred on January 8, 2019. Ultimately, this resulted in her client having to self-represent at a temporary hearing on January 28, 2019. During this proceeding, General Magistrate Deborah Nabet Frankel utilized attorney Renita Henry's misrepresented calculations while adjudicating a recommended order. The general magistrate supported her decision by saying it was temporary and that the judge would allow for corrections at the final hearing. But, on April 29, 2019, at the final hearing, Judge Scott Bernstein chose to generate a court order similar to General Magistrate Deborah Nabet Frankel's recommendation while advising the litigant to file an appeal of the verdict. This became a color of law because the verdict was adjudicated with the appearance of legal power to act that operated in violation of the law. This led to a lawsuit being filed against attorney Renita Henry by her former client for her involvement with what is classified as fraud on the court. Fraud on the court is typically limited to the most egregious conduct that implicates an officer of the court and occurs when material misrepresentation has been made to the court, or by the court itself. In this case, attorney Renita Henry misrepresented omissions as being materially admissible while possessing knowledge that it was a breach of Florida Statute 61.30. However, on August 6, 2020, Judge David Miller of the 11th Judicial Circuit Court of Florida dismissed the lawsuit while stating that the omissions were not fraudulent because the court was made aware and there were opportunities for corrections. The judge would recuse himself only a few minutes after generating his court order. With overwhelming evidence, the matter was petitioned to the 3rd District Court of Appeal in Florida on January 19, 2022. Undaunted by the supporting evidence which were submitted, Judges Gordo Logue and J.J. Lobrie dismissed the appeal of Judge David Miller's decision while stating that there were no omissions because attorney Renita Henry had intentions to later update her calculation. Yet, attorney Renita Henry chose to withdraw upon the request of her client to correct the omissions. Both judges would further identify the case as not fulfilling the elements of fraud. Through this statement, it was evident that these learned judges were more concerned with nullifying the prosecution of their peers than fulfilling their duty to protect and serve the Constitution of the United States of America. In doing so, they would further disregard judicial canon guidelines which require judges to report knowledge of impropriety to the relevant authorities. This story continued in April of this year with the filing of a 42 U.S.C. 1983 violation against attorney Renita Henry, attorney Emily Phillips, General Magistrate Deborah Nabet Frankel, General Magistrate Gina Mendez-Locke, Judge Scott Bernstein, Judge Samantha Ruiz-Cohen, Judge David Miller, and retired Judge Alan Fine. The case perpetrated further violations with a dismissal on April 4, 2023, by federal Judge Cecilia Altanaga of the Southern District Court of Florida, which was 20 days before the serving of the summons was completed. This further underlined Florida's position when it comes to prosecuting officers of the court who have omitted information about litigants during judicial proceedings. Additionally, on May 4, 2023, General Magistrate Gina Mendez-Locke, while acting as a hearing officer on the petition of the court by attorney Emily Joyce Phillips for enforcement of the verdict made by Judge Scott Bernstein in 2019, chose to reject the motion to vacate judgment. The General Magistrate further indicated that there was no motion to vacate judgment on the docket, while entry number 143 opposed that statement. In so doing, the court lost subject matter jurisdiction to hear the case based on the submission of an exhibit by attorney Amelia Lynn Warchel that was without Delaware state tax, Wilmington city tax, and mandatory retirement salary deductions. General Magistrate Gina Mendez-Locke also stated through a recommended order that any refusal of compliance would result in detention by the sheriff. Surprisingly, on May 9, 2023, Judge Samantha Ruiz-Cohen supported the General Magistrate's recommendation through the generation of a court order. What was interesting to note was the potential that was granted for retaliation, as Judge Samantha Ruiz-Cohen, General Magistrate Gina Mendez-Locke, and attorney Emily Phillips were all included as defendants in the litigants' federal lawsuit. It has been documented that complaints were submitted to Judge Bertela Soto, who is the former Chief Judge of the 11th Judicial Circuit of Florida, Judge Nushin Safai, who is the current Chief Judge of the 11th Judicial Circuit of Florida, Miami-Dade State Attorney Catherine Fernandez-Rundle, Florida Attorney General Ashley Moody, 32 Florida malpractice attorneys, the Florida Bar, the Judicial Qualification Commission, the Florida Governor's Office, the Department of Justice, and many more who chose to either not respond or decriminalize the act of omitting litigants' information during legal proceedings. Therefore, the question being asked would be, who is responsible for upholding accountability through the judiciary and the government as a whole? This case clearly demonstrates that the United States is now a beacon of injustice, inequality, and discrimination, all of which have no place in a democratic society. It should have been anticipated that oversight is not best practiced through the use of peers, which definitely has paved the way for experiences such as the one which is included in this video. Florida Statute 61.30, Florida Statute 839.13, Fraud on the Court, The Color of Law, and 42 U.S.C. 1983 were all violations that were utilized to infringe on this litigant's constitutional and civil rights. Nonetheless, highly studied legal professionals chose to trespass against these laws.